In this part, we will discuss use and misuse of the ordinance making power of Indian President. This video is also based on Spectrum's Indian Polity. In the Constituent Assembly, some members pointed out that the ordinance making power of the President was extraordinary and could be interpreted as going against constitutional morality. Some members felt that such a power was a relic of foreign rule. There were others who argued that the ordinance power should be left as a provision to be used only in the case of emergencies. The founding fathers of our constitution, amidst wide criticism, wished to retain the provision of ordinance mainly to meet any pressing need for legislation when either house is not in session. It is laid down clearly in Article 123(1) that the President is the sole judge of the circumstances which render it necessary for him to promulgate ordinances. But since the ordinance making power is to be exercised by the President on the aid and advice of the Council of Ministers as per Article 74, the power is often misused. It is misused in the sense that instead of meeting emergency situations, ordinances are being issued firstly by the governments of the day which do not have a majority. Secondly, by the governments which are not sure of the bill getting Parliament's support if brought in. And thirdly, to escape certain embarrassments in the Parliament. The United Front government under I.K. Gujral, even after losing its majority in the Parliament, after the withdrawal of support by Congress I, promulgated an ordinance on Prasar Bharati in December 1997 in the name of giving greater autonomy to the broadcasting institutions, that is All India Radio and Doordarshan. The minority government resorted to the ordinance route to give effect to the measure pending before the Parliament. In 1998, the BJP government, which had serious reservations over the 1997 Prasar Bharati ordinance, allowed the ordinance to lapse. Then, after making some changes in the key provisions, the Prasar Bharati Act was passed by the Lok Sabha, but it was pending in the Rajya Sabha, where the BJP did not have sufficient numbers. Hence, to bypass the Parliament, the government promulgated an ordinance in August 1998 to implement the provisions of the Act. Also, in 1986, the Congress government under Rajiv Gandhi promulgated the Inquiry Commission's Amendment Ordinance to avoid tabling the Thakkar Commission report before the Parliament. Why? Because it is obligatory for the government under the Commission of Inquiry Act 1952 to place the report of any inquiry commission before the Parliament within 6 months of its submission. The avoidance was mainly due to the fear of embarrassment that might have caused due to the debate on the report. Under the Prime Ministership of Jawaharlal Nehru, about 70 ordinances were promulgated between 1952 and 1964. Under Indira Gandhi, 77 ordinances were promulgated between 1971 and 1977. When Rajiv Gandhi was Prime Minister, 35 ordinances were issued in the course of 5 years. In these cases, ordinances were issued in spite of the government enjoying a majority in the Parliament. The minority Congress government of P.V. Narasimha Rao issued 77 ordinances in its 5-year term, that is 1991 to 96. The left-backed United Front government, which was also supported by the Congress from the outside, promulgated a record 77 ordinances during its term from 1996 to 1998 under the Prime Ministership of H.D. Deve Gowda and I.K. Gujral. The NDA government under Atal Bihari Vajpayee issued 58 ordinances between 1998 and 2004. In more recent times, the UPA governments promulgated scores of ordinances. The UPA 1 from 2004 to 9 promulgated 36 ordinances, while the UPA 2 from 2009 to 14 brought 25. Since May 2014, the Narendra Modi-led NDA government has promulgated several ordinances. The Land Acquisition Amendment Act 2013 ordinance, the most controversial one, was promulgated thrice in a row. Then the government allowed it to lapse. Regarding this ordinance, President Pranab Mukherjee asked the government to explain the urgency behind the ordinance. In January 2015, the President cautioned the government that the ordinance route should be taken only in compelling circumstances. Now let's discuss the point checks and balances. The ordinance making power has virtually allowed the executive to encroach upon the legislative sphere. The effectiveness of the government will be optimum if, as Jefferson remarked, the powers of government be so divided and balanced among several bodies of magistracy that none could transcend their legal limits without being effectively checked and restrained by the others. Thus, the two organs, the judiciary and the legislature, must be fine-tuned to check the misuse of ordinance-making power by the executive. The earlier Supreme Court judgments held that the presidential satisfaction was final for issuing an ordinance and cannot be questioned in any court of law, even where it is alleged that the power was not exercised in good faith, as in Lakshmi Narayan versus Province of Bihar 1950 and State of Punjab versus Satyapal 1969. However, in Cooper versus Union of India 1970, the apex court observed that the genuineness of the president's satisfaction could possibly be challenged in a court of law on the ground that it was malified. For instance, when the president prorogues a house of parliament in order to make an ordinance relating to a controversial matter so as to bypass the decision of the legislature. In 1975, the Congress government under Indira Gandhi, in order to avoid judicial interference, inserted clause 4 in Article 123 through the 38th Amendment. The amendment laid down that the President's satisfaction shall be final and could not be questioned in any court on any ground. But through the 44th Amendment, the Janta government did away with clause 4 and thus retained the Supreme Court's observation in Cooper's case. The point here is that though it is difficult to prove the grounds for malified, the court's observation acts as a potential check on any arbitrary power being used to prorogue the House of Parliament in order to issue ordinances. In DC Wadhwa versus State of Bihar, 1987, it was observed that successive re-promulgation of ordinances with the same text without any attempt to get the bills passed by the state assembly would be a fraud on the constitution, and the ordinance so re-promulgated is liable to be struck down. Thus, in extreme cases, the courts can invalidate an ordinance. This observation acts as an effective moral pressure on the president, the governors, and the cabinets. Now, parliamentary check. The Constitution in Article 123(2)(a) provides two parliamentary checks with regard to the promulgation of the ordinances. First, the power of Parliament to pass resolutions disapproving the provisions of the ordinance, and second, the automatic expiry of the ordinance within 6 weeks of the reassembly of the Houses of the Parliament unless passed by the Parliament, giving a chance for the Houses to debate on the ordinance and review it accordingly. But these two provisions have been manipulated by successive governments through the will of majority, more or less reducing the president to the status of a puppet. To change this trend, the Constitution needs to be suitably amended, but that is not likely to happen in the near future. However, an existing extra constitutional check can be made use of. It comes through Rule 71 of the Rules of Procedure of the Lok Sabha, and it states, first, whenever a bill seeking to replace an ordinance with or without modification is introduced in the House, there shall be placed before the House, along with the bill, a statement explaining the circumstances which had necessitated immediate legislation by ordinance. Second, whenever an ordinance that embodies wholly or partly or with modification the provisions of a bill pending before the House is promulgated, a statement explaining the circumstances which had necessitated immediate legislation by ordinance shall be laid on the table at the commencement of the session following the promulgation of the ordinance. But the main drawback of this rule is that it does not provide for an opportunity for a discussion or debate on the ordinances. It merely stipulates that government inform the House of the grounds advanced by the government itself. A provision in the same rule for a non-voting discussion is required. This would act as an effective bar to the misuse of the ordinance making power. That's it for this video. In next video, we'll discuss coalition government and India, reasons for the formation of coalitions, positive and negative aspects, how coalitions can be successful, the Indian scenario, steps to make coalitions effective.